My name is Barry Penner. I am the Managing Director of the Canadian International Internet Dispute Resolution Centre, which is a wholly owned subsidiary of the BC International Commercial Arbitration Centre, of which I'll say a bit more in a moment. I'm pleased to be joined by two esteemed colleagues. First, the Honourable Neil Brown, QC, who hails from down under in the land of Oz. And we'll be getting a presentation from Neil, as well as John Rogers, who is a lawyer practicing in British Columbia, Canada, out of Vancouver. They will take us through various perspectives on handling domain name disputes and offer a few key pointers for people that are entering into this area of practice or who've been at it for a while, but wouldn't mind getting a few pointers for people in the trenches. With that, I'll just advance to the next slide, assuming that there is a way to do that. This is just a bit of a busy slide just to show you that there's some news happening. I said at the outset that the parent company of Canadian International Internet Dispute Resolution Centre is the BC International Commercial Arbitration Centre, otherwise known as BCICAC. You'll see at the top of the screen there a reddish colored icon. It will be changing to the Vancouver International Arbitration Centre on September 1st, so in just about 2 weeks' time. Our parent company will have a new name, a new logo, but be located in exactly the same place, and will continue doing the same work that we've done since 1986. But after plenty of consultation, our board of directors has made the decision to adopt a new name and to rebrand. In keeping with that, we'll also have a new website address, which you may see at the end of this presentation. But I just want to let you know that that's happening September 1st. So BCICAC becomes the Vancouver International Arbitration Centre. But what we're really here to talk about is CIIDRC, or the Canadian International Internet Dispute Resolution Centre, which on September 1st will go from handling UDRP cases only to also handling .ca or CIRA cases. Currently, the CIRA cases are administered directly through BCICAC. But since we've set up this subsidiary, CIIDRC, and we have that new online platform, our board again felt it was prudent to move all of the dispute name business, both .ca and the UDRP or ICANN business through CIIDRC. So that's a little bit of housekeeping business I wanted to address right off the top. And with that, I'd like to now move to the more interesting part of the presentation, which is getting into the meat and potatoes and of domain name disputes and things to keep in mind. So that, I think it's over to the Honourable Neil Brown, QC.
Actually, Barry, I'm going to interject because I'm going to, if I may, put a few words in. Firstly, welcome everyone to the webinar. What the webinar, as from the name, is going to do is to focus on the UDRP, and Neil is the international expert on that, so I think we're very lucky to have him. What I'm going to do after Neil's presentation is spend a couple of minutes dealing with what are called the CDRP, the CIRA domain dispute resolution program or rules, procedures. And then we hopefully back to Barry and we can handle some of your questions. But before Neil, we get to Neil, I just wanted to put some of this in context. In sort of preparation for the webinar, I went and did a little exploration on the internet, and given some of the I think what's suggested is these days is fake news, I came up with some rather interesting numbers. Whether they're true or not, I don't know, but they make a rather interesting perspective, and they are the 7 most expensive domain names ever sold, and that's what we're talking about, are domain names. And if you look at the top 6, it goes from $17 million to almost $50 million. But the crowning one, if you will, and next slide, is Las Vegas. And according to this source, it's worth $90 million. So I would suggest that we put these numbers in the context of what Neil's going to help us with today. Neil, over to you in Australia, sir.
Well, thank you very much, John, and hello, ladies and gentlemen, wherever you are. It gives me great pleasure to contribute to this webinar today, this morning, in fact, in Australia, particularly because it is a webinar for the newly approved provider of dispute resolution services by ICANN, the company that in effect runs the internet. And what we will be looking at today is the work of the Canadian International Internet Dispute Resolution Centre and how it will apply the Uniform Domain Name Dispute Resolution Policy, which is the main body of law that deals with the resolution of disputes concerning the ownership and entitlement to internet domain names. So we're looking today then at disputes about the ownership and entitlement to domain names. It's an arbitration process, and its great advantage and value, of course, is that it is an arbitration process. Naturally, you can still go to law in the law courts of an appropriate country if you want to do that. But of course, international legal proceedings in courts are notorious for being long and notorious for being expensive, and there's always a lingering doubt whether you will ever get a result which is capable of being enforced. But the great advantage is, as you see from this first slide, if we could have that so that people can see it, the great advantage of the arbitration process under the UDRP is that you actually do get a result. The arbitration process results in an order being made that the domain name is transferred to the complainant, or of course that the complaint is dismissed, or that the domain name is simply cancelled. But at least you do get a result. You do get it quickly compared with court proceedings. You certainly get it quickly. A process under the UDRP arbitration process can be resolved in most cases within a couple of months. It can be done, and is done economically, because there are no great costs involved other than retaining your own lawyers, of course, if that's what you want to do. And you get some finality from the decision, because it's enforceable in a very simple, straightforward way. Let us say you are the complainant, and naturally you're hoping for success in the case, and success will be an order that the domain name be transferred to you. It's presently with the party who has registered it, in your view, improperly, and you have won the case, and you have an order from the arbitrator that the domain name should be transferred to you. That is enforceable simply because the order is given to the registrar, who keeps the registry of the domain name area where it is held, and the transfer will be made. If the transfer is not made in breach of that order, then of course the registrar will have to answer for not having done that, and will have to answer to the body which has provided the registrar with its accreditation. And I can assure you that is a very powerful incentive for the registrar to comply with the order that is made and which has been handed over to it, the registrar. So they are the good points about the arbitration process. And if we can go to the next slide, we'll just have a look at something around the edges, the broad picture concerning the process that we're talking about today. It's hard actually to get a precise number on the number of cases that have been decided, but you may be surprised to see and to read that there have been about 70,000 cases. I've done 2,000 of them, 2,000 almost, So I've got a fair feeling of how cases are won and certainly why they are lost. You can see the results of the cases because fortunately ICANN, the company that supervises the whole arbitration process through the providers of arbitration services, has passed a rule that the decisions that we make as arbitrators or panelists must be made public. That is quite unusual in the arbitration process, one of the features of which is that it's private and confidential. But in the arbitration process for domain names, that is not so. It is all open. Everyone can see the good, the bad, and the ugly. If there is any of that, the latter, you can certainly see the whole text of all decisions made emanating from all proceedings brought under the Uniform Domain Name Dispute Resolution Policy. And they are put on the websites of as there are now 6 providers. We are concentrating today, of course, not to criticize any other provider of arbitration services, but we are gathered today to learn something about the work of the Canadian body. And as you see, that website is CIIDRC.org. And if you go to that website even today, you will find that the Canadian body has already handled a series of cases, and the decisions made in those cases are public and available for you to read. Likewise, decisions from WIPO, the other provider that you see there. Forum is the one you may have known in the past as the National Arbitration Forum in Minneapolis in the United States, now known as Forum. The next one is the Asian Domain Name Dispute Resolution Center, which actually has several offices. It's a very able and competent organization. It has several offices in Asia, and a number of the Asian countries are participant members of that, you might say, federal body, the Asian Domain Name Dispute Resolution Center. The CAC is the Czech Arbitration Court, which now arbitrates on disputes under the UDRP like the other providers. It initially was involved in commercial arbitration and of course still is. And in the domain name field, it is the provider of arbitration services for the big .eu range of domain names. We are not specifically concerned with that today, but it is a very important area of domain name arbitration conducted by the Czech Arbitration Court. The last one is the Arab body, which is in Jordan. And they have done a few cases. They're also new, like our Canadian colleagues, whom we are looking at more closely today. And as I say, they have had a few cases in the Arab Center. I've already told you that the CIIDRC, or CIDRC as we call it, their decisions are on the website, and I would recommend that you have a look at those decisions so that you'll be able to see that CIDRC is fully operational and is handling cases and has promulgated some quite interesting decisions. If we could go to the next slide, we'll have another look at the area that we are looking at today. I'm not going to talk down to you, of course, and assume that you don't know what a domain name is. I'm sure that you would not be taking part in this webinar if you did not know, but just for the record and to get our minds thinking along the right lines, a domain name, as you know, is a name to identify a site or an address on the internet, and it is used to support email services. It's used to support websites, and of course is therefore at the fulcrum of the whole structure of the internet and the use of the internet today for providing commercial transactions and of course an enormous amount of social communication between people. Let's just, for those who perhaps may not be so familiar with some of the detail, concentrate for a moment on a couple of things. I've given you there the domain names of two Canadian bodies, the Canadian Pacific Railway and Air Canada. You'll notice there is a difference between the two of them. The Canadian Pacific Railway has decided to take what we call a country code domain name. That is one which, as you can see, .ca being the call sign for Canada, confined to that terminology for their own particular reasons. There is no reason why they could not have a .com domain name. There is no reason why they could not have both. Most companies have quite a lot, but their prominent one is the Canadian.ca, and that's how that is normally expressed there, as you see on the screen, as a Canadian domain name. Air Canada has a .com, and therefore disputes that arise under domain names of that nature are exactly what we are concerned with today. They are handled under the Uniform Domain Name Dispute Resolution Policy, which we have already referred to and which is our main area of study today. Just notice as we go by that you'll often see www.cpr.ca, and you'll see the same thing with .com domain names. What you see there, no matter what anyone tells you, are not domain names. They are instructions to your computer, which will respond to the www when you type it in by going to the World Wide Web. And then for some curious reason, which is really not widely understood by the community at large, and I wouldn't pretend to understand it perfectly myself, but when it has gone to the www, the World Wide Web, it will then go and par the then domain name, take cpr.ca, for example, will par that backwards, and it will go to the .ca part of the internet first, and then, because that is the instruction that you are giving it, it will go to the CPR part of that section of the internet. So it is a way of getting into the domain name, if you like, on your computer. You will also see domain names used frequently, of course, in the structure which appears immediately under that. You're sending an email to John Doe, who works for the Canadian Pacific Railway, where you will address it to the recipient, not surprisingly, like any letter, and the address is at the domain name. The next one, resolution.institute, illustrates another thing that I think I should point out to you, that the really good thing that ICANN has been engaged on over the last couple of years has been to create a range of what are referred to as new top-level domains. You can think of them as an umbrella, because under that umbrella, those domain names issued under the top-level domains, like .institute, are gathered. The Resolution Institute is an arbitration body in Australia, and it had a Resolution Institute domain name when ICANN introduced the new range of top-level domains. One of them was and is .institute. So the Resolution Institute very cleverly and very sensibly decided that it would take a domain name, call it Resolution, and under the .institute umbrella, lo and behold, it ends up with a domain name which is its entire name. So that is resolution.institute. And all domain names are issued under one or other of those top-level domains. For all practical purposes, I've set it out there. I thought the expression "the legacy ones" is probably a good umbrella to describe that group. You might like to describe them as the big league, the .coms, the .nets, .info. .tv is one of the country code domain names, one of the country code top-level domains for the country Tuvalu. As you can imagine, they're very happy to get the callsign.tv. And indeed, it provides, as I understand it, most of the national income of the country of Tuvalu, which is one of our neighbors in the Pacific Ocean and actually one of the largest countries in the world, but with a very small population. .asia is a comparatively new top-level domain, its objective being to provide a sort of general link through all countries in Asia, and it's actually got off the ground and is functioning well and has a very large range of popular domain names under that umbrella. There are others, of course, .eu, the Australian one, for example, .au. XXX is the, if I can think of a polite expression to refer to it, is I think adult entertainment. It has a separate umbrella, and under that range, the exciting and interesting domain names that I will leave to your imagination to speculate on arise, and disputes arise naturally from them. And we have the onerous burden of reading all of the evidence closely relating to domain names and websites emanating in that field. So they are the legacy ones that we had until a couple of years ago, when ICANN embarked upon this new program of expanding the range of the internet, and has done that very successfully with a range of new top-level domains, like, as you see them there, .Nike. You can have one revolving around a single company. .NYC for New York City, you can have one like that, where all of the domain names issued under that umbrella will relate to activities in New York City. .food, .club, .Quebec, you have one specifically for that Canadian province, just as you have one .Melbourne and another one .Sydney. Altogether, there are, believe it or not, it's hard to imagine, but there are now 1,238, as of yesterday, 1,238 top-level domains, or umbrellas, if you like, under which domain names can be issued with those links with a specific area or a specific activity like food, a specific grouping like club, or a province or state like Quebec, or a city like Melbourne. And that is the current very, very, very extensive range of the internet and the vast umbrella under which domain names are issued. So if we go to the next slide, we will then get into the precise area we are concerned with today, namely disputes. And I've asked the question there, what are the disputes that are arbitrated under the Uniform Domain Name Dispute Resolution Policy? You could say there's a category of genuine commercial disputes concerning domain names, which arise, say, for example, between principals and agents. Say if a real estate agent had employed an agent who subsequently left the firm, but before he or she left and during the happy days of the agency, that agent registered the domain name, but registered it in his or her own name. Is the entitlement to a domain name the person in whose name it is registered, and can that be challenged, or is it or should it be an entitlement for the principal who has engaged the agent? That's a question I'm asking, and we won't pause to answer it immediately. But the same issue arises, say, in partnerships. If there are two partners, one of them has registered the domain name in his or her own name, and the partnership then comes to an end for some reason, and a dispute arises. As to who has the entitlement to that domain name when, in the happy days when the partnership was chugging along merrily, the domain name was registered in the name of one partner. So those sorts of disputes arise under the Uniform Domain Name dispute resolution policy. A very common or frequently arising area of disputes arises between, say, motor car manufacturers and their distributors, or the providers of internet software and their distributors around the world. If the domain name has been registered by the distributor, say if the distributor registered the domain name Mercedes-Benz Quebec, who has the primary entitlement to that domain? Is it Mercedes-Benz, or is it the distributor who, in happy days of the relationship with Mercedes-Benz, registered the domain name in his or her own name? That is the sort of question that arises in this genuine commercial dispute area of disputation about domain names. A second area would be, I've used the word cyber squatting there, which is the more blatant and brazen occupation of space in the domain name and internet area by someone who really has no entitlement to occupy it, but simply does it in an opportunistic way, hoping perhaps that the other party will one day try and buy them out, or for whatever sequence of events they can imagine. But it's simply squatting, as the name implies, on an area or space of the internet to which it is alleged they have no right to do. Then we get into the nasty cases, and some of them are a bit that way, I'm afraid, where a domain name has been registered and used for the purpose of a fraud, like the popular one of phishing, phishing with a P, that is, phishing for information, which can be used for tempting parties to pay their bills to the wrong person. They are scams, which in Australia, and I'm sure wherever you may be, it happens there also. Celebrities and their brands are sitting ducks, like poor old Jimmy Choo, who seems to have got caught up in quite a lot of these, cases where a party, for its own material benefit and without any scruples of any sort, really, takes the domain name which will either use the name of a celebrity or a celebrity brand, or will contrive a domain name which is very similar to it, and where some people will mistake it for being a domain name and hence a website of the real celebrity and the real provider of the celebrity brand. The particularly nasty one, of course, is pharmaceuticals, not only because it is a breach of the pharmaceutical company's trademark to try to copy it and then sell generic brands of drugs. Not only is it bad, of course, for that reason from an intellectual property point of view, but it is inevitably particularly dangerous where you're buying a drug which has the same name as a well-known and approved brand of pharmaceuticals, or you are buying a drug on the internet which has a similar name and it is claimed that it is the same as a particular product or drug, and in fact it's not. And in fact, as in some cases, regrettably, it is a defective product with unfortunate results. So that is another category of the way in which these sorts of disputes arise, where they are not simply occupying a space on the internet like cyber squatting, where they might be fraudulent or counterfeiting. They might be actual commercial disputes in a what you might call a genuine dispute between partners or agents. Then, of course, is the other area where people construct a domain name and link it to a pornography site and make money by that means. The current one which is all the vogue these days, so I'm informed, is Pornhub.com. You might, I originally, when I was preparing this slide and these comments, going to say pornography now has a much smaller role in the internet than you might imagine or have been led to believe. But on an examination of some of the evidence that I was forced to read in a recent case, very reluctantly, as you can imagine, I found that in the year 2019, there were 42 billion hits on this one internet website, 42 billion visits, as they politely refer to it, in 2019. That is just to one pornographic website. I was curious, not that it was part of the case, of course, as to what was the population of the Earth on the same day. And the population on New Year's Eve 2019, the population of the planet that we inhabit was 7.7 billion, which would appear to suggest that the population of the globe did very little in 2019 except visit the website Pornhub.com. And each person on the planet seems to have visited it 6 times. I don't visit it, of course, so the statistics are thoroughly unreliable, but this might give you some framework of the heavy burden that is imposed on us when we arbitrate on these cases and have to examine meticulously from a professional point of view whether the evidence comes up to scratch or not. In any event, that's the sort of dispute we are concerned with, and you will therefore be interested when we go on to the next slide, please, to notice that there is a ready-made compulsory arbitration process in every agreement relating to every domain name which is issued. And the reason why that is so and how it comes about is that ICANN, the company that runs the internet, in effect, has devised a very original and sensible compulsory dispute resolution arbitration process. And it obliges this process to be embedded into every contract between anyone who registers a domain name and the registrar who has provided that domain name to them. So the individual takes a domain name, goes to their computer, decides that the name is good and the price is good, so they press that submit button without, of course, reading the agreement to which they are agreeing themselves, and that agreement with the registrar whom they are paying for the domain name includes compulsorily the compulsory arbitration process known as the Uniform Domain Name Dispute Resolution process, which is the subject of our discussion today. So in other words, the disputes we have been looking at just now, they are resolved by a compulsory arbitration process to which the registrant or owner of the domain name is bound from the day that they buy the domain name. So that's what the UDRP is. That's in a nutshell what it does and where it comes from. And if we go to the next slide, then we will see as an example, it's no more than an example, it's not a terribly significant case, but it concerns the well-known Madonna. There is a case concerning her domain name, Madonna.com, which was registered by a gentleman, Mr. Parisi, who was not unknown to the practice of registering domain names. It was registered, of course, with a registrar, Network Solutions, as you see, and it was linked to a pornography site, www.madonna.com. That was arbitrated on the papers by an arbitrator appointed under the UDRP. The result was what we call a transfer. In other words, the order was made that the domain name be transferred to Madonna, and she therefore won the case. It's an illustration of another proposition, incidentally, that was not mentioned in the decision, other than in a peripheral way. The argument put up by Parisi as his defense for holding on to this domain name, which was that Madonna had no reputation, so she could not lose her reputation and could not suffer. That is, of course, a silly argument. It is irrelevant to the issues in an arbitration in this field, but it is a silly and foolish argument, apart from being incorrect, as a matter of fact, and illustrates the proposition that if you find you are on the receiving end of a complaint under this process, in other words, if you are a respondent to this process, don't rely upon silly arguments like that, because it will be counterproductive. If we go to the next slide, we will have a look at the macro, the macro situation, and we will ask ourselves, how are these results determined? Well, the answer is simple. The rules which apply, and they are in writing, so there can be no dispute about them. The rules are carry a provision that the arbitrator is to apply the documents filed in the case, but also, as you see from that quote there, any rules and principles of law that that is the panel, the arbitrators panel, it deems applicable. So it's a very good power to give to arbitrators, and we're very happy to have that, because to bring about a just and a sensible and balanced result, we can apply any principle of law which we believe is applicable. And when we do that, there is a choice open to us, only a limited choice. The choice open to us is to order that the transfer of the domain name takes place in the case we've just been looking at, that it is transferred to the complainant, in that case, Madonna. As you see, if you jump to the bottom of the slide, if Madonna had lost the case, the complaint would have been denied, and the registrant of the domain name, the respondent, would keep it as a result of winning. The only other alternative which is open to an arbitrator under this system is to order that the domain name be cancelled. As you can see, it is a limited process in the sense that we cannot issue injunctions, we cannot award damages, we don't have those other powers that a court has. It is concentrated on this issue of who should be entitled to this domain name. If the complainant who is bringing the claim wins, then the domain name may be transferred to that party. It could be cancelled altogether, or the complaint could be denied, and the domain name remains with the happy party who registered it in the first place. Cancellation of a domain name is an odd remedy, of course, because yes, you can have a domain name cancelled under this process, but if it is cancelled, anyone may then register that same name again. So even the unsuccessful respondent could apply to register the same domain name again. So it's a sort of Pyrrhic victory to get an order for cancellation, and very few cases actually ask for a cancellation. Some do, because some companies take, the one that always sticks in my mind is BMW. Everyone seems to want a domain name with BMW in it for some reason, and BMW naturally get very sick and tired of it. So companies like BMW, and certainly companies which the Australians would know very much, like Telstra, I have seen several occasions they ask for cancellation rather than transfer. They would prefer rather simply to be rid of the domain name rather than to have it registered by themselves. Interesting, an interesting concept. I would not ask for cancellation myself. I would ask for transfer. And if we go to the next slide, we'll see how that works out in practice. I won't bore you with the details of how those figures there on the percentages were collected, but if you looked at a broad range of decisions under this process, which have been made in WIPO, which is the World Intellectual Property Organization, it's one of the 6 providers. Of all their cases, it's now roughly 83% have been won by complainants, that is by the trademark owner who brings the complaint against the registrant of the domain name. The respondent has won, in other words, has held on to the domain name in 15% of cases, and only a minuscule percentage of them have been ordered. If you're interested in some sort of comparison with the Australian domain name space, the country code of the .coms.au in Australia, the transfer rate is actually lower. In other words, complainants marginally do not do as well. Perhaps the arbitrators under the Australian system are more strict or draconian or require a higher standard of proof. But the figures speak for themselves, I suppose, to some extent, that complainants or plaintiffs in the UDRP area seem to do better than they do in some country code structures. And if we go to the next slide, we can take this a bit further by telling you what is the process, which will not come as much of a surprise to you. Say if you wanted to bring an arbitration process under this procedure to get your hands on a domain name that you are entitled to, you would file a complaint, a fairly, let me rephrase that, it's a straightforward form that tells your story as to why you believe the respondent is not entitled to the domain name registered in its name, and why you should be. One of the interesting things about this process is that you can file your claim with any of the 6 providers. You in Vancouver, not that I would recommend that you do this, of course, but you could file your complaint anywhere in the world, and they could file a complaint in the Canadian provider. Another advantage of the system, and again an oddity in terms of arbitration and litigation, is that this major problem of serving the complaint or originating process on the defendant or respondent, that is done by the provider. So you don't have to go out knocking on doors or slipping the complaint under their front door at midnight or anything like that. They then have 20 days, the respondent that is, to put in a response. Most cases are not defended. In most cases, the respondent takes the view, it seems, well, the game is up, they think. We may as well just let this claim result in an order, being that we lose the domain name. We enjoyed having it while we did, and we made some money out of it, perhaps, in the meantime, but we won't fight it to the bitter death on the barricades. When the response comes in, or if there is no response filed from the respondent, the provider will appoint a panel to resolve the case. Normally it will be a one-person or single-member panel, that's most cases, but either party, the complainant or the respondent, has the right to ask for a 3-person panel. When you get down to tin tacks and drill into this system, you'll find that respondents do much better when they have a 3-person tribunal than if they had a 1-person tribunal. The reason for that is said to be, well, in the first place, they have an automatic right to nominate or recommend or appoint one member of the three-person panel, and they also have a right to participate with the provider in the appointment of the chairperson, the third member of the panel. And the view amongst some people is that this gives the respondent a better opportunity. It certainly gives it an opportunity to air its argument before a wider audience and to expand on some of the more interesting aspects of the case, which perhaps might not be concentrated on if the case were before a single member rather than a three-person tribunal. All of that, of course, is argumentative, but I just put it forward to you as a view that you might like to think about. If you're going to ask me what I would do, if I were a respondent, I would always ask for a three-person tribunal, and I would pay the part of the fee that I am then obliged to pay to ensure that I did have a three-person tribunal. The complainant pays for the whole lot if it ends up with a single-member tribunal. If it's a three-person tribunal, the complainant and the respondent both make a contribution to it, which is only fair. All right, the next important step, and it's a good thing to have, is that the panelist, or panelists, plural, must make a declaration that they are independent and neutral, and that they will do their best and act properly and genuinely in their role as arbitrator. And that must be provided to the provider. The panelists must give that undertaking. The panelists then have 14 days to make their decision, which is a point worth making because it shows you this is not a process which sits around going nowhere week after week and month after month, or in litigation in some countries year after year. This is a case where the panel, the judges, if you like, are required under the rules to give their decision within 14 days. There can be an extension, but they are reluctant to have an extension. We all like to have our decisions done within the 14 days, and most of them, of course, are done without any extension of time. And that decision then goes off to the provider, who gives it to the registrar. And as I said, it is then carried out. Say if the complainant was successful and the order was that the domain name must be transferred, what happens is that there's a sort of cooling off period for 10 days, just in case the defeated complainant wants to appeal, for instance, or the respondent wants to appeal, I beg your pardon, is more likely. There's a cooling off period, and then the order is implemented and the domain name would be transferred to the successful complainant. So if we went on then over the page, now we know, if the next slide could come up, please. Before we go on, I can't tell you everything about this process and how to win a case or how to lose a case. I can't do all that today, but I can tell you where you can do a lot of interesting reading. WIPO, one of the providers, has a document it calls an overview, which I would recommend, so long as you do not regard the decisions as binding, because they are not binding. Arbitration decisions cannot be binding, except as between the parties. But it is a very interesting collection of views of panelists who sit in this field as a contribution to trying to get regularity in the decision-making process and some degree of regularity, so that if a question arises to you about a case that you are thinking of bringing, and the question is, well, how are the arbitrators going to take this argument? Will they accept it or not? You can go to that overview and you'll get a fairly good idea on most contentious issues of what the panelists have been doing on that issue. Of course, what the outcome is will depend on the evidence, as it should, and on the arguments that are advanced in the course of the arbitration. Another source which you could use, and here I must make a declaration, which is this is my website, www.domaintimes.info. What I do there, and it's a rod for my own back, but we keep at it, is to look at as many decisions as we can, and we put up interesting ones on our website to draw attention to them and to say, look, this is what happened in this case. Be careful, it might happen to you, or you might like to follow what happened in this case. There is a very valuable textbook, and if you can see what I'm holding up, which I hope you can see it's a fairly substantial tome. It's a very good book written by Mr. Gerald Devine in New York, and it's called, not surprisingly, Domain Name Arbitration. I mention Amazon there to avoid lines and lines of print about booksellers. I mention Amazon because you can buy it on Amazon. You might find that as a shortcut. But I would say keep yourself up to date with Domain Times. Have a look at it. You can write for it if you like, if you're particularly interested in this field. Have a look at it, but also have a look at the WIPO overview. But in particular, look at Mr. Levine's book, which will tell you what way matters have been decided and how various principles are emerging now as a result of these many thousands of cases. And if we go on to the next slide, we will find in a bit more detail, and I know I'm taking up time, but I hope not too much, and I will move as quickly as I can through this next section, which deals with what do you have to prove in a case like this, or what do you have to disprove, I suppose, if you're on the receiving end as a respondent. Bear in mind, when we look at the three elements that you will have to prove, that you have to prove all three. You must prove them by evidence, and you must prove them by evidence on the balance of probabilities, because it is a civil case. They say in real estate, if you ask a real estate agent, what are the three most significant factors in deciding whether someone will buy a house or not? They are location, location, and location. I always say in a UDRP domain name case, the three most important aspects are evidence, evidence, and evidence. Remember these cases, and the decisions are based on facts. And if you are involved in cases like this, it's your obligation as a lawyer, and it's your benefit and privilege as a party to make sure that all of the relevant evidence that helps your case is put in front of the arbitrator and the panel. Because, and if we go to the next slide, you will see the answer to that you have to prove these three elements. Let me just take a minute to walk you through them. The first element that you must prove is one that aims directly at the complainant trademark owner. And what that party, the complainant, the trademark owner, must prove is that it has a trademark or a service mark, and the domain name that is at issue is identical to his trademark. Or if it's not identical, it's confusingly similar. So you'll see that really doesn't have much to do with the respondent who presently owns the domain name, but it has a lot to do with the domain name itself and what the trademark owner, plaintiff, complainant has to prove to get the case off the ground and to establish its standing to bring the claim. The second element that must be proved is that something that goes directly to the party who has registered the domain name. and you as the complainant will have to prove, either by direct evidence or by inference, and it's often by inference, of course, that the party who has registered the domain name has no right and no interest in it in a legal sense, no right to do it. You have no right to be there at all. Obviously a contentious area. And the third element, as you can see, there's quite a lot for you to prove in these cases. You have to prove that the domain name was registered in bad faith and that it is being used in bad faith. Notice, incidentally, and a lot of people overlook it, it's probably one of the most valuable pieces of assistance I can give you today. Notice the use of the word and in all those places. The word and connects element 1 with 2 and 2 with 3, and therefore you have to prove all 3. Notice also that in the linchpin, the bad faith, you have to prove that your respondent has been doing things in bad faith, but bad faith when they registered the domain name and bad faith when it was being used. I had a case a couple of months ago where a firm of lawyers advanced the argument that the expression registered and used means registered or used. A very strange argument, you would have thought, but one that was seriously advanced and very quickly rejected, because with that you don't have to go anywhere beyond the basic rule of interpreting acts of parliament and legal documents, namely take the simple approach of what do the words actually mean. So that's our structure. Let us go to the next slide and look for a minute at the first one to give you a feel of how that works. Remember, the trademark owner must prove that it has a trademark and that the domain name is identical to that trademark, or it's confusingly similar, that it's similar and people could be confused. Is this a domain name of the trademark owner, or is it a domain name of the of somebody else? Let me give you some examples. And if this were not a webinar, I, of course, would be asking you these questions and asking for the answers from the audience. But as it's a webinar, let me put it this way. I think you would agree that, as in that case, would you not, that the domain name onthego.com is identical to the trademark On The Go. Not much scope for disagreement about that, especially if you lop off the .com, which you do when you're making this comparison. So that's an obvious example. Let's have a look at one slightly more difficult on the next slide. I think you would probably agree that the domain name Dell Technologies is similar and confusingly similar to the trademark Dell, would you not? And the reason why you would probably think it's confusingly similar is that the whole of the trademark Dell is embedded in the domain name Dell Technologies. And also, you know, because everyone knows, that the Dell Computer Company is a technology company. And that brings them closer together and would probably persuade you that that domain name is confusingly similar to the trademark Dell. Before we go on, this case is illustrates also another principle I mentioned in passing before, the principle being don't raise silly arguments, because if you do, you will antagonize the arbitrator and probably lose. Because in that case, the respondent who registered the domain name Dell Technologies said he had never heard of the company Dell. And furthermore, what he meant by Dell Technologies was an area in a forest where fairies and mystic figures and pixies dance around in the fairies' dell. And of course, the arbitrator said, not in these words, of course, that that is absolutely absurd, and went on to say that if the respondent believes that, He must be the only person on earth who would believe it. Let me look at a difficult one and leave you with an interesting question. There is a whole series of cases where people, for whatever reason, usually because, well, sometimes they are disgruntled ex-employees, but for whatever reason, they register the domain name Chubb Sucks, for instance, meaning in a derogatory sense, Chubb is a bad company and it does bad things. Is that domain name identical to the trade name Chubb? No, it is not. Is it similar? Well, it has a similarity, of course, because the word Chubb is in there. Is it confusingly similar? Would anyone looking at that domain think that that had been concocted by Chubb itself, or that it was concocted by somebody else for a bad purpose? I've just left that with you as a question and made the note to you there that domain names which are sucks companies, where that word is added, are a matter of never-ending controversy. It's bound up in a particular American issue, of course, because of the First Amendment to the United States Constitution, guaranteeing freedom of speech and freedom of expression. That sucks cases are used to show on a website why Chubb, for instance, or Air France, which was another one, in the opinion of the respondent, why they suck, to use a derogatory term. In other words, why they are devoid of morality or principle, according to the person who is running this website. And of course, once you get into that argument of free speech and the issue of whether it should be balanced, is there a public interest in allowing unlimited free speech in the internet and in the construction of domain names, or is the principal interest, the interest of protecting the rights of property vested in a trademark owner who has the complaint? Interesting question, and I will leave it to you today to reflect on that as an issue. I was able to squeeze in to the slide just at the end this note. So also, that is also an area of controversy, may be cases which are based on a very recent, this case was only decided a few days ago in the forum, the Harston Sanger case, where the domain name was compared to Hastings. And the argument on one side was compared to Hastings could be confused as being an infringement on the Hastings trademark. The other side of the argument is no, compared to means that it's not Hastings, but it's something where you're making a comparison with Hastings. The panelists involved reached the decision on that issue that that was confusingly similar to Hastings, despite the fact that the argument compared to meant that it was something that was not Hastings, but was being compared with it. So that's a very interesting area, and I think the compared to cases will become an area of controversy. Could we go to the next slide, please? I know, and say before we go on that I've mentioned several times that, and there's a big argument about whether this should have been done or not, but it was done and it has been done. And one of the elements that must be proved in these cases by the complainant is that it has a trademark. It's either a registered or an unregistered common law trademark, but if you don't have your registered trademark, you won't be able to get the case off the ground. That is not the case with a lot of country code policies like the Indian one, where it's a name trademark or service mark. So you can have just a name, not necessarily a trademark, and you'll be able to bring a claim under the Indian policy, but not under the UDRP. And if you go to the next slide, you will see that some people, particularly celebrities, get into terrible difficulties because they don't have a registered trademark and they have to prove that they've established a common law trademark in their own name. In other words, that in the name in question, it has acquired a meaning in the world at large, which is not simply its literal meaning, which is a primary meaning, but it has acquired a secondary meaning, meaning this is the trademark of my goods and services. Hillary Clinton was able to do this because she had to do it when she was seeking that domain name back. Someone had registered it improperly using her name, Hillary Clinton, and she wanted to use it for the presidential election campaign of which she was a party. And if we go to the next slide, we can see that she was able to do this because she had published books, which are goods, and she'd published them in her own name. So she was able to establish and the next slide, please. She was able to establish a common law trademark to enable her to get rid of this HillaryClinton.com website, which had references to Monica Lewinsky and all sorts of other things in it. And she was able, if we could go to the next slide, she was able to use it in her election campaign. Okay, moving on, we go to the next slide. And the second element, which is to show that the registrant has no right or legitimate interest in this domain name at all. Often, of course, the respondent will have a right, namely that there was nothing wrong in registering the domain name and first come, first served. But if we go over the page, go to the next slide, we will see that the domain name registrant can defeat the claim by showing that he or she has an interest in the domain name or a right to register it by proving any one of a number of things. And there are lots of bases on which respondents can and sometimes do win cases. So if we go to the next slide, you will find that the first one that might get the respondent out of trouble is if the domain name is really its own name, if the respondent is known by the domain name. Classic one, which illustrates the other principle that it's always wise to choose your parents very carefully. Mr. A. Armani, who lived actually in Vancouver, his address, surprisingly enough, is in the decision. He registered the domain name Armani.com because his name was Marnie and the initials of his two given names were A and R. Giorgio Armani took a great exception to this, of course, brought this claim, but Mr. Armani was successful, if we go to the next slide, and he got the domain name because the arbitrator ruled that Armani was his own name. But if you look at it today, you'll find it has nothing to do with Mr. Armani in Vancouver and has everything to do with Giorgio Armani, meaning that Mr. Armani was very lucky in having Giorgio Armani buy it from him. There can't be any other explanation unless he surrendered it voluntarily. He may be on the beach in Acapulco spending the proceeds for all we know, excuse me, but for whatever, that's a good illustration of what can be done. And if we go to the next slide, we will find that there are some other grounds that the respondent may be able to rely on. For instance, if the respondent was using the domain name for a bona fide business and was doing so before the dispute was brought to its notice, or if it's, say, a generic or dictionary word, or if it was a domain name like Quebec.com, which was arbitrated by 3 arbitrators, including the great Nelson Landry, one of your arbitrators. I was on this panel of 3 with him. And as with the bona fide business, which is the first ground I mentioned there, or as with the ground that the domain name is simply a generic or dictionary word to which nobody can have exclusive rights, my domain name is around that generic word, or it's around a geographic region like Quebec. In those cases, the view of panelists and the view which is embodied actually in some cases like this in the UDRP itself is that if you are acting legitimately and you're not trying to target the trademark owner who has the same name, then you may well succeed in holding on to the domain name simply because it was legitimate for you to be using it for a bona fide business before the dispute arose, or it's part of the ordinary language embodied in the dictionary or in generic expressions, or that it's the name of a municipality or a region like Quebec, then the respondent has a good argument for saying, well, this should not be the prerogative solely of the trademark owner. This should be something to which I have a right, so long as I don't go trying to undermine the trademark owner, so long as I don't try to pass myself off as the trademark owner, so long as I don't act improperly, I should be able to keep this domain name. And respondents quite rightly do win some cases after advancing those arguments, provided always, of course, and it's something I can't emphasize too much, provided that the facts come up to scratch. So evidence is particularly important. If you want an argument that your domain name is simply a generic word, you have to show that that is the case. And also you have to show that you've not been using it improperly to target the trademark owner. You will have to show that you used the, on evidence, say by affidavit, that you were using it for a bona fide business before the dispute arose. There's one remaining area on that list, of course, and it is an important one. A respondent will be able to succeed because they have a right or legitimate interest in the domain name by showing that it's non-commercial or a fair use of the domain name, such as, if we go to the next slide, a genuine criticism site. You can look that case up yourself in the WIPO case list on its website. That was a case concerning a genuine criticism site, and the respondent was able to hold on to the domain name for that reason. If we go on to the next slide, people, as you may know, you may run one yourself, or have a genuine fan site. If you're using a genuine fan site, which is embodied around the domain name of the author of your favorite author of a series of books, in this one it was GaryJennings.com. If what you are running is a fan site and it's a genuine one, not just a colorable pretense for running a commercial website, but a genuine fan site, then you will have a very good chance of winning and holding on to your domain name. Next slide will show us the third element, which I said before, is probably the most important in the sense that this is all really about good or bad faith. Has the respondent who registered this domain name acted in good faith, or have they been acting badly and improperly? And the UDRP provides, of course, that you must prove that it was registered in bad faith and used in bad faith. Some of the country code policies, as I've already told you, like the Indian one, it's enough if you can prove that it was registered or used in bad faith. But for us in the big league of .com, you must prove both. In Australia, it's or. In the .eu space, it's or. In Canada, Canada has a very sensible one for the .ca domain name structure. You have to prove that the domain name was registered. That's the only requirement, but it is a sole and unique requirement. You must prove that it was registered in bad faith. Singapore is or, and US, by which I mean .us, not in the United States, because the United States has, of course, far more .com domain names than it has .us domain names. But under the US own domestic country code.us, it's OR. So that's what you're up against. It's no good proving that when the respondent registered the domain name, it was all lovely and done for the best of motives, so it was not registered in bad faith. But then later on, say when there was a takeover bid and the name became famous on the market, then you held on to it and tried to copy it, pretending that it was the trademark owner's website. That's no good if all you can prove is registration in good faith and use in bad faith. You have to show on the evidence either that it was clearly and deliberately registered in bad faith, or that the inference from all the only available evidence is that it must have been registered in bad faith as well as used in bad faith. So if we go on to the next slide, this is an example of bad faith, and it's the way in which, regrettably, the internet is used. And it's a very good example, I think. It's a one concerning Australia. If you just look at the little bit of information there at the top, Austin Robinson was a real estate agent in a suburb in Sydney called Harbord, and he registered the domain name Harbord Real Estate, claiming that what he was doing was registering the generic expression Harbord Real Estate, meaning real estate in Harbord. The complainant, which is called the Harbord Real Estate Agency, of course, disagreed with that and took great exception, because what Mr. Robinson was doing was, when people like you or I were clicking on Harbord Real Estate .com, looking for Harbord Real Estate, the company, our hits on the website were being redirected to Mr. Austin Robinson's website, and he was getting the business from these potential buyers or sellers of houses. Now, that is bad faith on any traditional moral view, I would have thought, because it's cheating, it's pretending that what I have done in my website will lead you to a website dealing with all real estate in general in Harbord, whereas in reality, it will lead you only to the way Mr. Austin Robinson, the real estate agent, buys and sells real estate in Harbord. I think a fairly clear case. A fairly clear case if we go, I think, towards the end to my favorite domain name case. For those of you who have had a misspent youth, would be familiar with the Legend of Zelda. You may not be familiar with young Mr. Alex Jones, who is an aficionado of Legend of Zelda. And he registered the domain name legendofzelda.com because Nintendo was so foolish that they hadn't registered the name of their own computer game as a trademark or as a domain name. They registered the trademark, but not as a domain name. And Alex Jones set up this website to deal with character development, gossip, stories, illustrations, but not commerce. He was praising it. He was a devotee of it. And the arbitrator who decided this case, in my view, quite rightly said, look, it's not bad faith. If anything, this was good faith. He was promoting Legend of Zelda. He was not pretending he was Legend of Zelda. He was not pretending that he was able to produce a rival or counterfeit Legend of Zelda game. He was doing nothing but advancing the cause and popularity of Nintendo's own Legend of Zelda game. So that could not be called bad faith. And I think he was right on that. I think he's absolutely right. And hence, my favorite domain name case, I think, resulted in a victory for young Alex Jones, who was then able to carry on with his website for many years after that. And if we go to the next slide, that is also bad faith. If you're creating confusion in the market, that's clearly bad faith, and the policy says so. So if you set up a domain name and a website and you steal Novatel's name and you put it in your domain name, which you have called Center or Centre Hotel Novotel, and you use it to promote not Novotel hotels, but you use it to promote your own rival competitive hotel booking agency, that is bad faith because it's misleading the public. It's creating a confusion in the public that your domain name will lead to a website which will advance the wares of the Novotel hotel chain, whereas in fact it advances your own wares. Not theirs, and you're doing it by using their name and trademark under that guise. And if we went to the next slide, you will see the happy news that the UDRP is the vehicle for the compulsory arbitration of disputes over domain names. There are going to be a lot more of them because of the new generic top-level domains. And inevitably there will be disputes about them, and you'll be very relieved to hear that all I'm going to do is to raise that question and not tell you how it has been answered, except very briefly, and invite you to read at your leisure the next slide, and the introduction being that to show you what an enormous change has been wrought in the internet. That's what we had. And if you go to the next slide, that's what we've got now, multiplied by many times. 1,200 umbrellas we now have, 1,200 new top-level domains within which domain names may be registered. And they are, I can tell you, for instance, you've got a whole battery now of domain umbrellas, as I call them, for brands like Kiwi, places like Quebec, .Quebec. So you don't have to slug it out with Quebec.com anymore. You can have 100,000 domain names ending in Quebec if you want to. And you've got general ones like .tattoo, .accountants is a very popular one, .tax and financial, and others. And if we go to the next slide, you will see that, as I've said before, and to the next slide, this just says there are disputes. There are disputes about whether the new umbrellas or range of top-level domains should be approved at all. We had a series of disputes. I sat on a number of those. And then, of course, inevitable disputes about domain names issued under the new generic top-level domains, the new umbrellas. And if we go, because I've promised you, it is there for you to read. If we go to the next slide, I will simply say goodbye by saying two things, I think. The first is you've got here at least the information you can work on. You've got the ICANN website. You've got a paper I wrote on the new generic top-level domains, which is on that website, and you have the website itself, domaintimes.info. And now, although I've promised this several times, I hope when we go to the next slide, this is the last slide where this information is contained. Yes, indeed it is. Those new range, you've got to give it to ICANN. You've got to concede to ICANN. It has been very, very good in setting up structures to resolve all of these disputes under the new domain name, top domain name structure. I'm not going to go into those because it's too complicated and we'll be here for weeks if we go into those. Simply tell you they are there. Please read about them. If you need any help, contact me, or for that matter, any of the other operators, I'm sure would be prepared to help, and I would. And if we go to the next slide, the next slide clearly has nothing to do with me at all, and I'm therefore happy to say, I hope the information I've given you has been of some value. It's the barest outline, of course, but I think it's a good system. It's a good structure, what we've been talking about. It resolves disputes, a lot of them. It resolves them in a quick way, in a fairly basic, down-to-earth way. But of course, they can't be resolved unless they're in the hands of a good provider of arbitration services. And our friends here at CIDRC, the Canadian Centre, have already established themselves as being competent in this field. I have had a couple of cases already in this field. They have always, and I've had a few .ca cases. I can give you my word that they have all been handled professionally and quickly, and that's what you want. Miss Aina Sugar, Miss Aina Ergashiva looks after her panel of arbitrators in a very effective way. We are submissive, of course, to her dictates. She keeps us in line and up to the mark, and we try to do a good job. I think we do, and I leave you with that decision, which is ultimately yours, of course, about using CEDRC or one of the other providers. But I think my role is, as it should be, is to say that it is a good, competent body administering claims under what is a good, competent and effective arbitration process. So thank you very much indeed.
Thank you, Neil. And at this point, without further ado, I'd like to turn it to John Rogers.
Thanks. Thank you very much, Barry. We're almost out of time, and I want to leave time for questions. So I'll go through mine very quickly. As you'll see from the slide there, that the CDRP process is very much similar to what Neil's gone through, except for one thing, and I just want to touch on, that's the Canadian presence requirements. I'll get to a minute. There are two service providers under the CDRP, and that is CIDRC and Resolution Canada. Next slide, please. For the under the CDRP, it requires that if a complainant is going to operate within the CDRP, they must meet the Canadian presence requirements. Next slide, please. And the purpose of that, and you'll see I put it up there, but it's basically the intention is that the CIRA environment, the .ca environment, is a key public resource for the social and economic development of all Canadians. So the intention is to show a, if you will, a significant connection with Canada. Next slide, please. Can we do the next? And so if you run through it, you'll see there's a list of a number, next slide, please, of those criteria. Next slide, please. And it runs from a Canadian corporation to a Canadian citizen to a legal entity, even the Queen, the Majesty of the Queen, and if you will, an Indigenous band. Next slide, please. And if the complainant doesn't qualify for any of those, then if the complainant has a trademark or official mark registered within Canada in the Canadian Intellectual Property Office, then it can qualify. But there's a big but. Next slide, please. That is that the trademark or the official mark must consist of the exact word component of the .ca domain name. And there have been situations where you've got cyber squatting or typo squatting, where the domain name being complained of does not have the exact registered trademark or official mark, and then unfortunately the complainant didn't qualify. Next slide, please. And that's it. Again, Neil, thank you very much for your presentation. That's excellent and demonstrates your expertise. Barry, over to you.
Great. So at this point, I know we've received a couple of questions, and I believe we still have time to field those. So one of the questions that came in through the chat feature of the Q&A was, how does the option of going to court, as indicated at the start, sit with the compulsory dispute resolution arbitration policy that's mentioned by Neil on slide 9.
It was always thought by ICANN that it should keep open this prospect of taking court proceedings if that's what you wanted. However, the purpose of the arbitration process was really to avoid the pitfalls of litigation. After all, if you were bringing the normal domain name claim that you bring under the UDRP, if you were bringing that in a court, first of all, you would have to find a court that had jurisdiction over that claim. Secondly, you would have to find your defendant, and it has unique and particular problems in domain names because people who register domain names are not always accurate in giving the registrant's name. In other words, they may give a false name. You have to find where the respondent is domiciled so that you can serve the proceedings on it. You would have to prove your case in a court by traditional means of evidence, subject to the rules of evidence. And then, most importantly of all, if you won the case and you got an injunction, say, to have the domain name transferred to you, you would have to enforce that court decision. And that is a difficult thing to do. Those of you who are lawyers would know how difficult it is. You have to find a place where the court decision can be registered and executed. And how are you going to do that? It would be very difficult to do even in a domestic context because courts are reluctant to make orders requiring people to do things and then expect the court to supervise them being done. So all of those problems are avoided by this unique method of arbitration and the attractions that it has. So when you put the rival merits in two columns, one for court proceedings and one for the arbitration process, if what you want is the domain name and you don't want damages or anything else by way of a fancy remedy, if what you want is the domain name itself, then there is no doubt at all the arbitration process is the better of the two.
Barry, if I could just add to that, under CIRA, firstly, I agree with Neil. Ideally, you do deal in the context of the UDRP or CDRP. But for the person asking the questions, I direct them to Rule 13 of the CIRA rules. And what it sets out is that if either during the proceeding or it's prior to the proceeding, the court situation or a court application goes ahead, the panel can always adjourn or stay or terminate the proceeding if it so just determines. But have a look, if you will, at Rule 13 at CIRA. They deal with that.
Yeah, true.
All right, move to we have 2 questions we'll try and squeeze in. We're into overtime now. If a domain name registrant wants to sell their domain name, price at whatever value they deem applicable, and list it for sale, are they considered to have rights to the domain name?
Well, it's a pity we have only a few minutes, but let's just go on as long as we can on this because the issue is an important one and a big one. By and large, the first principle I think to get straight is that if you are otherwise entitled to the domain name, you are entitled to sell it. It has been held, if it needed to be held, by courts that domain names are personal property, so they can be sold, they can be mortgaged or inherited, or anything can be done with them. So there is a right there. That, I think, is the first and substantial argument we should get clear in our heads. But how you go about it, selling it, is something you have to be very, very careful about, because one of the grounds spelt out in the UDRP for proving bad faith in registration is that, well, when you acquired the domain name, you did it for the purpose of selling it or renting it out to the very claimant trademark owner who is now claiming it from you. That is said to be bad faith because, in other words, you were not registering or acquiring or buying the domain name yourself for a good and legitimate purpose, but for a purpose which was bad in itself, namely to sell it to the complainant or someone who is in competition with the complainant so that they could use it and damage the complainant's business by claiming they were the complainant. So if there is evidence that goes to show that that's what your real intention was from day one when you acquired the domain name, you could be in real trouble. The way it works out in practice, where it is not literally a problem, is where the offer to sell is actually not an offer to sell, but an offer to buy. In other words, the claimant trademark owner comes along and either under its own name or by some surrogate tries to buy the domain name. That is really not something that can be pinned on the registrant because it didn't start it. The registrant who owns the domain name did not start that process. They were not making overtures to sell the domain name. They were having overtures made to them to sell it. So it's something you have to be careful about in the language that you use for fear that you don't fall into that trap. I could go on about this, but of course one gets into that situation where every case depends on different facts. But they are the basic principles. If the question really is trying to get at, do you have a right to sell it? The answer is yes, you do, because it's your property. But if you are selling a domain name which is a brazen copy of a trademark, and the facts otherwise show that you were ill-intentioned, then you could land yourself in trouble. So always, the bottom line is always get advice before you engage in anything remotely like that activity.
Under CIRA, just as Neil had suggested, registration in bad faith, 3.51 says the registrant registered the domain name or acquired the registration primarily for the purpose of selling, renting, licensing, or otherwise transferring the registration to the complainant. If you are a complainant and you are objecting and you believe that the registrant is in the business, if you will, some of the most effective evidence that you can put forward to the panel is that you have gone to the registrant and started a negotiation, if you will, to acquire the domain name. Quite often, those negotiations will certainly help the complainant's cause markedly in the complaint. So if you are a complainant, if you believe that a registrant has a domain name and has it basically there to sell back to you at some stage, I would encourage you to go down that process to be able to demonstrate the provisions of 3.51A or 3.5, either 1 or A, depending on which version you're looking at of the policy.
Yes.
Right. Noting that we're now over time, I will just point out the final question here. There's Maria Lopez asks, Mr. Brown, is it true that the next new GTLD round will come soon? Have we heard anything about that?
I think in a nutshell, yes. The latest intelligence I have is that it is going ahead. So that itself is news and a significant step. It is going ahead, and um, soon, I suppose, it's a bit like beauty, isn't it? It's in the eye of the beholder. What is soon? Some people were on reasonable grounds expecting that this would be well underway by now, but I gather it's not. But I think the answer is a guarded yes. Yes, soon, but not too soon, perhaps. Not too soon for some people, perhaps sooner than others would like, because there was a lot of objection, of course, to having the system of new GTLDs launched at all. There was a strong argument advanced and strong political pressure used to prevent it from happening. But ICANN's view, for which there is some support, is that it was opening up competition and expanding the proper and legitimate use of the internet, and should be advanced for that reason. I think the preponderance of view would be, although I can see now over the horizon, the longer one goes on this subject, the more trouble one might end up getting into. I think the prevailing view, if there is a general view, is that yes, it has proved to be useful, but perhaps not as useful in some areas as some people had expected or thought. And I think it's probably wise to leave it there. What I will do, you've made me concentrate on that issue now. What I will do is find out from various sources the latest intelligence on the answer to that question, and I will put it up on the website at domaintimes.info as soon as I get something intelligible to impart to the rest of the world. How about that?
I think that sounds great.
Right.
And I think at that point, we should maybe wrap it up. I again
Okay.
want to thank everyone for tuning in and for joining Honorable Neil Brown, QC, and Learned Counsel John with us today. It was, I think, a pretty thorough discussion, but I'm sure there's still some additional questions. So if you have additional questions, feel free to contact us here at the CII DRC, and we'll either endeavor to answer them ourselves, or if need be, we'll get in touch with both John Rogers and or Neil Brown. And without any further ado, then, I would bid you all a good day.
Thank you, John.
Thanks, Neil.